Good morning, Honorable Nhlanhla. Good morning, Honorable Nhlanhla. Good morning, Honorable Skosana. Good morning, Honorable Nomvalo. Good morning, Honorable Shongwe. Good morning, Honorable Breitenbach.
Morning, Chair.
Thank you so much. Good morning, Honorable Cameron.
Good morning, Chair.
Good morning to you. Good morning, Honorable Kola Barnard.
Good morning, Chair.
Good morning to you too. Good morning, Honorable Thop.
Good morning, Chair.
A very good morning to you. Good morning, Honorable Malema. Good morning, Honorable Matthys. Good morning, Honorable Mwango. Good morning, Honorable Sols. Good morning, Honorable Vessels,
Good morning, Chairperson.
and welcome.
Thank you very much.
Yeah, we missed you in the last meeting, but your apology was accordingly recorded that you were out on other parliamentary engagements. Thank you so much for
I was
reaching.
far away, Chairperson, in Asia, and I'm glad to be back home.
Yeah. Thank you so much for rejoining us. Honorable James, good morning to you.
Good morning, Chair.
Honorable Sangoni, you are now here. Good morning to you.
Good morning, Honorable Chairperson, honorable members. Apologies, I missed you calling me the first time, Chair. Thank you so much.
You are welcome. Honorable Ngola, good morning to you. Okay, can we check Mr. Ramano? Do we have apologies for the honorable members who have not exchanged pleasantries with the chairperson?
Good morning, Chair, honorable members and colleagues. I'm informed that Honorable Source will join us later. He's attending a virtual swearing-in ceremony of one of his MPs. Secondly, Honorable Matthys also tendered apology. She might join us later. Those are the only two that I have.
Honorable Mwango, good morning.
Good morning. Good morning, Honorable Chairperson. Good morning, colleagues.
Bangazita. Can I check, honorable members? Let me do the rotation and check if there are apologies that you would like to tender in the meetings. Honorable Sangoni.
Thank you very much, Chairperson. There's just one apology from me, Chair, that I requested to please be excused at 1 o'clock if we're not yet done. Honorable Ntuli and Honorable Sokanyile are just running a little bit late, but they will be joining us as well. Thank you very much, Chair.
Thank you so much. I can hear that you are struggling with a common illness, which is very prevalent during this time of the year. And we hope that you will recover soon. It's not a threat. Don't threaten yourself and think you are sick. This is just
Thank you, Chair.
it's a common occurrence during this time of the year. Honorable Breitenbach. any
Yeah.
apologies?
No, Chair, we're all online. I will be in and out of the meeting. I have other obligations as well, but we will be present for the entire time. Thank you.
Thank you so much. Honorable Mnango, any apologies?
Well, Chair, perhaps around 12 o'clock, I would be required to attend to another very short commitment and then rejoin the meeting thereafter.
Okay, thank you so much. Honorable Vessels, any apologies?
No apology. Thank you, Chair.
Thank you so much. Honorable James, any apologies?
No apologies from my side. Thanks, Chair.
Okay, let me extend my greetings to the content team and Nicolette.
Honorable Chair, I'm also here.
Yes, no, we greeted you and there was loud silence.
My apologies, Chair.
Greeting,
I'd like to be released as well at 12.
greetings
And then
to you.
same to you, Chairperson. And
You're
Honorable
welcome.
Mata is in a flight.
Okay.
Thanks.
Thank you so much. Good morning to you, Miss Van Zyl-Gous, Miss Silkstone, Dr. Bok. Good morning, Mr. Tejana. And
Good morning,
I
Chair.
see
Morning, Chair.
we have
Good morning,
also
Chair.
been joined by Bonga from Parliament Monitoring Group. Good morning to you. And all the media houses that have joined us, we want to appreciate your presence in this meeting. Thank you so much to all of you who have created time to be with us in this meeting today. And honorable members, we note the apologies that members have submitted to the meeting. This meeting is a continuation of what happened in the last meeting. You would remember in the last meeting, we gave each and every member an opportunity to give their own impressions about the draft report and also on the findings and recommendations. And when the meeting was closed, we agreed that the content team will go and reconcile areas of convergence and areas of divergence. And where there are common findings and recommendations, they will alert us to that. And where there are divergence in terms of findings and recommendations, or there are multiple views, they will also do the same, and the committee will pay attention to that. Where there is agreement, it means those areas of divergence which we will have found each other will then be added to those that where there is common findings and recommendations, and where we are unable to find each other, the committee may decide on the route of making majority findings and minority findings, as well as majority findings and as well as majority recommendations and minority recommendations. So this is the item for which we called the meeting, and I'm aware that there were other items in the last meeting that we could not deal with, and we agreed that we will allocate a day where we will come and deal with those items. So I want to check, or let me say, I want to persuade committee members that given the apologies that we received today, let's focus ourselves to the draft report. And then maybe before the end of this week or early next week, we come and deal with those issues. One issue was raised by Honorable Matthys about the statements that were made by Honorable Shongwe, or the testimony of Honorable Shongwe at the Nhlanhla Commission. And there is also a matter of the threats that Honorable Shongwe would have received from Mr. Paul O'Sullivan. So those are amongst the matters that we may need to come back before the end of this week or early next week to deal with them. I want to persuade you, honorable members, given the apologies of today, that we focus on the report. Can I check if there is agreement, Honorable Sangweni?
That's fine, Honorable Chairperson, no problem, we can do that.
Thank you so much, Honorable Breitenbach.
That's fine, thanks, Chair.
Honorable Malema.
Agreed, Chair.
Honorable Mnango.
Agreed, Chair.
Honorable Vessels.
Agreed, Chairperson.
Honorable James.
Agree, Chair.
Honorable Skosana, if you would have joined, can I check if you agree? Or Honorable Shongwe, Honorable Nomvalo, any one of you who would have joined by now, do you agree with the suggestion? Honorable Sols, if he has joined, do you agree with the proposal? Okay, I take it that the meeting unanimously agrees that we must proceed with the draft, the second draft preliminary report as the only item of this meeting. And to ease the members, I'm going to allow the content team just to alert you to the areas where the committee has common views and recommendations. And then the second part will be where there are multiple views and recommendations. And once the report is presented, I'm going to rotate amongst all members because this is a meeting where we have agreed that we are going to finalize the report. Even if there is any other matter, either on the introduction or on the background, where members may want to bring to light, you are allowed to do so. And I'm going to encourage all of you as members to speak so that you make use of the opportunity that you are given to express yourself on this report. And also to remind you that we have said that we are not adopting the report today, we are finalizing it so that we can send it to the affected parties for their comments. And for a period of about 10 days. And when the report comes back to the committee, those comments would be considered and the report will be up for adoption. Ms. Van Zyl-Gous, I'm handing over to you.
Good morning, Honorable Chairperson, and to each honorable member. I will hand over, Chair, to Ms. Christine Folkestone to take members through the report. Thank you, Chair.
Good morning, members. I've prepared a very short presentation and I won't go through all the slides. I will just deal with the areas that the chair has outlined. I I'm going to try and share. I'm not very good at sharing documents. I always get myself rather confused. When Mkhwanazi, do you think you can help me? Okay, now I found it. Okay. Okay. So, Banana, let's skip to the first page, the next slide. Okay. So, as the chair said, the purpose of this briefing is to guide members through the findings and recommendations. That's sections 14 and 15 of the report, of the draft report, and to identify really the areas where there appear to be broad convergence, to identify matters that require, final in brackets, deliberation, especially individual findings and targeted referrals, and to show how party proposals are reflected without turning all proposals into committee findings. Next slide. We can go on to the next one. Okay. So the approach to the findings and recommendations is that the committee is an oversight body. It's not a court or a prosecuting authority, and this actually shapes how we craft our findings and recommendations. The findings distinguish between established governance weaknesses, unresolved allegations, institutional risk, and matters requiring referral. A referral is not a finding of criminal guilt, civil liability, or disciplinary culpability. Where the evidence was incomplete, indirect, classified, and therefore the committee didn't have access, contested or not tested with the affected person, the report uses cautious language. Recommendations identify what should happen next and which institution should act. So the broad areas of agreement, in fact, there was really a lot of convergence. There is a need for clearer executive operational boundaries in policing. There's a need for better governance of specialized units and task teams. There's a need for improved docket control, case continuity, and evidence safeguards. Crime intelligence needs requires reform, including looking at the vetting, access control, funding, and oversight. Procurement and conflict of interest controls also require strengthening. Interagency coordination between SAPS, DPCI, IDAC, IPID, and MPA is fragmented. And I'd like to put in brackets there, like sometimes hostile. Whistleblower, witness, and internal reporting mechanisms require improvement, and Parliament requires a structured mechanism to monitor implementation. Next slide. Okay, so the findings, I'm just going to quickly run through the findings 1 to 4. Governance, that deals with governance, the directive itself, the task teams, and dockets. That was the PKTT dockets. So finding 1, the evidence disclosed systemic governance weaknesses, not only an isolated administrative dispute. The second finding was that the 31 December 2024 directive was issued and implemented through a materially deficient governance process. Finding 3, governance of specialized units and temporary task teams is inadequate. Docket control is finding 4, docket control, case continuity and evidentiary safeguards require strengthening. And so the deliberation focus there, does the wording capture the directive, the PKT status, the docket transfer, and operational continuity concerns sufficiently well? Next slide. Findings 5 to 9. These deal with the crime intelligence, procurement, and informal influence. So findings 5 and 6 are actually they deal with crime intelligence. So crime intelligence is affected by serious structural integrity vulnerabilities. And findings 6 deals with its funding, its classification, the issue of classification and oversight arrangements, which do not provide adequate assurance. Finding 7 deals with leadership, delegation, discipline, and command governance processes, which require strengthening. Finding 8 deals with the Medicaid 24 procurement process, which was affected by serious irregularities and control failures. Finding 9 deals with informal influence and improperly managed relationships which have created institutional integrity risks. So the deliberation focus here is the draft report firm enough on procurement and relationships without overstating culpability. The next slide, sorry. Findings 10 to 70. Here we deal with institutional risk, oversight and public trust. So finding 10 deals with a serious vulnerability within the criminal justice system to organized crime influence, which was disclosed, but there was no finding of a single controlling cartel or cartels. Finding 11, the interagency coordination is fragmented and insufficiently regulated. Finding 12, the MPA and IDEC safeguards require focused assessment. Finding 13, police accountability and civilian oversight mechanisms require strengthening. Findings 14 and 15, internal reporting, witness protection, and whistleblower protections are inadequate. Findings 16 and 17, parliamentary oversight, implementation, follow-up, institutional culture, and public confidence require attention. Next slide. Now, finding 18, and I think this will be likely to be the main area for final deliberation. Finding 18 is deliberately differentiated rather than uniform. It deals with individual accountability and referrals. So some individual matters support governance or accountability findings. Some matters are serious but unresolved and are therefore referred for assessment or further assessment. Where a person did not testify, the report avoids adverse findings and records the limitation. Where evidence is disputed or indirect, the report avoids findings of guilt and identifies what must be verified. Next slide. Okay. So individual matters that are likely to require deliberation. With Minister Nkunu, the directive, the Mkhwanazi relationship, executive accountability and the limits of the evidence. Lieutenant General Sabir, the dockets, directive implementation, the Mkhwanazi, Nhlanhla and the relationships, and Nhlanhla and the alleged false affidavit, the Rolex issue. General Masemola, command accountability, directive response, and Medicaid 24 warning. Mr. Nhlanhla and Mr. Mkhwanazi, Medicaid 24, access to officials and SAPT information, payments, claimed influence, and crime intelligence links. Mr. Chele, the Nhlanhla allegations, alleged payments, intervention, and hearsay limitations. IDAC, MPA actors, the mandate, interagency, safeguards, independence, and case handling concerns. And then members, private individuals, persons not heard, and that looks around classified information, private investigative conduct, and evidentiary limits. Okay, next slide. Sorry, the next slide. Okay, so looking at the recommendations, 15.2 to 15.4, they look at core governance reform. So 15.2 deals with legislative reform, institutional alignment, and system modernization. 15.3 deals with executive operational boundaries that clarify the minister, national commission, and operational command roles, or they address those. 15.4, that deals with specialized units and task schemes, regulate the establishment, mandate, resourcing, reporting, performance, and disbandment. It includes the need to ensure that temporary task teams do not operate indefinitely without clear authority and oversight. So the deliberation focus will be, it suggests that there is the proposed review process and identification of the responsible institutions sufficiently clear. Next slide. The ones from 15.5 to 15.8, they deal with the dockets, crime intelligence, and procurement. So 15.5 has recommendations concerning docket control, case continuity, evidence management, and digital audit trails. 15.6 has recommendations addressing crime intelligence and intelligence governance reform, which are addressing including vetting, access control, classification, and secret expenditure. 15.7 looks at leadership accountability, integrity, and procurement governance, including due diligence and conflict controls. 15.8 organized, organized, 15.8 deals with organized crime infiltration and institutional resilience. And deals with, sorry, I got distracted by something. The deliberation focuses, are the recommendations practical, monitorable, and assigned to the correct authorities? So it's similar to the previous recommendations. Next slide. So recommendations 15.9 to 11 address coordination, the MPA, IDAC, and the IMCs. So 15.9 has recommendations concerning operational coordination, case flow, and interagency clarity. 15.10 has recommendations to strengthen the MPA and IDAC, including its independence. Yes, accountability, operational and financial, funding, capacity, safeguards, and legislative review. The MPA Act should also consider the Minister of Justice and Constitutional Development's final responsibility, executive responsibility, and safeguards against overreach or interference. So this is the same executive operational, or similar to the one in policing. 15.11 is the interministerial committees. We clarify the terms of reference, reporting, records, and limits of operational authority. Here, the deliberation focus is, again, executive accountability must be preserved without compromising prosecutorial independence. So we're suggesting that is really the focus. 15.12 deals with police accountability, IPID, civilian oversight, and institutional integrity. 15.3, whistleblower and witness protection, including a threat assessment and support. 15.4, institutional culture, discipline, ethics, and public communication. 15.5, the parliamentary monitoring, disclosure, and reporting duties, including an implementation tracker. This also addresses the classified information access and the need for a clearer parliamentary mechanism involving the JSC where required. The next slides. Okay, here, this is where I think the members will probably want to do most of the deliberations. It's 15.16. The targeted referrals. The section deals with matters that require assessment by competent authorities. It should identify the issue, responsible authority, records to be assessed, and the reporting route back to Parliament. So there's a loop. It should not prejudge criminal, civil, or disciplinary liability. It should prevent conflicted persons from controlling the response to referrals involving them. So here the deliberation focus is each referral sufficiently specific? Sorry, there's a typo there. And has any proposed party referral been admitted or should be recorded as a party view? Next slide. So how the party proposals are reflected in the report? They're either adopted, so reflected substantially in the findings or recommendations. They're adopted in part, so they're reflected but not in the full terms proposed. Mostly they're reformulated, so the substance is retained, but in more cautious committee language. Referral only, serious but unresolved matters are referred for assessment by a competent authority. They're recorded as a party view, so this included, suggestion is that we either do it as an annexure, but not adopted as a committee finding or recommendation, they're not adopted, unsupported, untested, outside mandate, duplicative, or requiring separate process, or if there's formal dissent, they're recorded separately if submitted by a party. Next slide. Okay, so just to say that some party proposals are reflected in the report, but not in the exact terms proposed. The main reasons are the committee is not a court, the evidence was incomplete, contested, or indirect, the affected person did not testify, or the issue requires a competent process. Where appropriate, the report treats the matter as a limitation or a moderated finding, a referral, or a party view. This doesn't mean that the issue is unimportant or it's not reflected. It means that the committee has avoided making findings that the record cannot safely support. Next slide. Okay, so the non-adopted or moderated views around individual culpability. Minister Mkhwanazi, the report finds executive accountability unresolved integrity concerns, but does not find a proven corrupt agreement or cartel instruction. Around Lieutenant Severe, the report finds serious unresolved issues and referrals, and makes referrals, but does not find that he acted for Mr. Nhlanhla, Mr. Mkhwanazi, or an organized crime network. Ms. Chelly, the allegations by Mr. Nhlanhla and the Rolex false affidavit issue are referred or assessed cautiously, but there's no finding of corruption, perjury, or extortion. Advocate Johnson, IDAC, the report recommends institutional assurance and oversight, but does not make a personal, criminal, or disciplinary finding against Advocate Johnson. Honourable Adams and Honourable Kola Barnett, the concerns about sensitive information are recorded in the report, but no concluded finding or unlawful disclosure is made. The next slide. Major General Khan, and these are persons who weren't heard or the evidence was not tested. So Major General Khan, the report records that his absence limited the committee's ability to resolve allegations concerning him, but no adverse finding is found. Mr. Malefe and Mr. Mamela, the report does not describe either person as a cartel or syndicate member unless established by a competent process. Commissioner Julius Mkhwanazi, the report does not make a criminal or disciplinary finding, but supports verification of existing mechanisms or investigations or complaints. Mr. O'Sullivan and Ms. Trent, the report records concerns about private investigative conduct and access to information. Specific matters are referred to only where capable of verification. And note that late, incomplete, or unauthenticated material is not used as a sole basis for adverse findings. Next, non-adopted, again, the institutional claims. It's the issue around the single cartel or syndicate control. So the report makes serious organized crime finding recommendation around the serious organized crime for vulnerability, but does not find one controlling cartel across all the institutions. Around judicial, prosecutorial, or IDAC capture, the report identifies institutional risk and safeguards, the need for safeguards, but does not make concluded capture findings against institutions or named officials. All informal social contact as corrupt. The report treats unmanaged relationships as integrity risks, not as proof that every contact was unlawful. Around crime intelligence allegations depended on access to classified material, which the committee didn't have. The report records that the JSC IGI access limitation, records the JSC IGI access limitation and recommends the need for a clearer classified information mechanism. Legislative or constitutional redesign proposals, these are reflected as matters for review, not as immediate committee findings. Next slide. Where is that? Okay. So suggested decision part: first, confirm agreement on the institutional and systemic findings. Second, deliberate on the individual findings and whether any wording must be strengthened, moderated, or moved to referrals. Confirm targeted referrals and responsible authorities. Fourth, confirm treatment of any formal dissenting views. Fifth, authorize technical corrections, numbering, cross-references, and formatting before adoption and tabling. The intended outcome is a report that is firm on governance, fair on individual accountability, and practical in implementation. I think that's the last slide, but thank you.
Thank you so much, Ms. Silkstone, and the team that you represent. Honorable members, in the last meeting, all of you made submissions, and the team went to integrate all the submissions and reconcile them where there are areas of agreement and where there are multiple views. They have delineated that. So what I'm going to do now is that we are going to rotate amongst the members. I'm going to call you one by one so that you make your observations. If there could still be any other points that you raised in the last meeting and they are missing, you bring that to the attention of the meeting and the content team. There are three members, Honorable Sangoni, Honorable Malema, and Honorable Mkhwanazi, who have requested to be released at 12. And I'm going to give them the opportunity, if they are ready now to start, to make their own observations or any other matters that they may want to bring to the attention of the committee, which they strongly feel must go into the report. Can I check with yourself, honorable members, Honorable Sangoni, Honorable Malema, and Honorable Mkhwanazi, if you are all ready? Honorable Sangoni, are you
Thank
ready?
you. Thank you very much, Honorable Chairperson.
Just for a moment, I'm taking your level of readiness. Are you ready?
Yeah.
Okay.
Although we're not quite sure how to handle this, but yes, Chairperson.
Let me check with Honorable Malema. Honorable Malema, are you ready with your observations?
Yeah, I'm here, Chair.
Okay, Honorable Mkhwanazi, are you ready?
Yes,
Okay, what is the issue, Honorable Sangoni?
Chairperson, I suppose the issue is that this would be the third time that as the African National Congress we would be contributing to this process. You'll remember that we would have submitted our written report, which the team was expected to go and consider and include. The second time was in the physical meeting that we had at Good Hope Chambers, I think a week or two ago. Now we're coming back, and while we don't expect that each and every single recommendation that we would have made would necessarily find itself into the document, but we believe that a lot of what we would have put forward for consideration has either not been captured at all without any reasons given for why it is not captured. If you look at the presentation that we just got, it indicates how recommendations or findings proposed by parties would have been treated. But I don't know what the basis of either rejecting or not including recommendations would be, because we did not necessarily deliberate as members and agree to remove or to include a particular finding or recommendation. But Chair, Also, we get the comment that is made about how some recommendations would have been moderated. In our view, we would even go so far as to say they have been diluted. As the ANC, we took particular attention to ensure that we don't make findings of culpability, of guilt, couched it in oversight terms, but still those recommendations have been diluted, Chair. I'll give you one or two examples. One of the issues that we had raised, and it bothers us very much the way that these matters have been captured, would have been on the issue of the classified information that was in the possession of Honorable Kola Barnard as well as Honorable Adams. Now, if you just read the draft report that we have been given, it seems to create doubt on whether this information was classified or not, whereas in the evidence, it was very clear from General Kumalo and I think one or two others that this information is indeed classified. And we had made a specific recommendation there around a referral to the Ethics Committee in relation to the two members who had possession of that classified information, as well as an assessment by the JSCI. Now, when you read the recommendations, there seems to be no view in that matter, and it's couched in very, 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 as I said, diluted terms. Whereas if you contrast that, for example, with the findings that are made against General Ele, which seem to impute criminal liability and are calling for a direct criminal investigation against General Ele, the same caution that is used in the case of the two MPs is not there. So there are quite a few issues for us, Chair. If you go through, for example, some of the recommendations we had made around legislative amendments, I'll use the example we had made about a separation between the administrative as well as the police functionality of the SAPS, where we had a direct recommendation that the Civilian Secretariat for Police should be the accounting authority for the SAPS, and that you should retain the National Commissioner as the operational head of the police service, not responsible for administration. Again, such recommendations, which are quite straightforward, which we don't believe go into the terrain of making any findings outside of our scope as Parliament, they are not captured. And then there's quite a number of them. So I'm not sure, Chair, if what we are now trying to do, I don't think it serves any purpose for us to restate the recommendations that we had made, or do we then go into what perhaps the committee staff would have considered areas of disagreement and maybe resolve those ones? I think we'll probably need to take guidance from yourself in that regard, Chair. Thank you very much.
Yeah, this is what I said in the opening remarks, that I allow members to bring any matter, especially that when we adjourned last time, we said the next meeting or the following meeting will be the meeting to finalize the report. So if you have a very strong feeling that there are matters that you have raised not once, but several times, and those matters are not in the report, you have to raise, you will do justice for yourself if you raise those matters in this meeting. Because my understanding, Honorable Members, is that once this report is finalized, even before we send it out to the affected parties like we have agreed, it still have to be shared with yourselves, you see it. And then once you have okayed it, we can send it out. Does that give you comfort, members?
Yes, thank you, Chairperson.
Yeah. So I'm going to give you an opportunity to make your observations on the report. Even if you want to start with the introduction, you say anything you want to say, from the book of Genesis to the book of Revelations.
Okay, thank you, Chair. Maybe let me start and then other members of the ANC will come in, Chair. Chairperson, the first one was on the issue of on the directive on the ports of entry. I think that we had made a number of observations regarding that issue at the ports of entry, but we had a specific recommendation around the vetting of all SAPS members at the border posts. But also we had called for a clarification of responsibilities between the Border Management Authority as well as SAPS at the borders. So we would want to see that recommendation there. We don't think that the recommendation 15.12.19 captures it correctly, and we think that that one has been diluted in a sense. On the issue of sorry. On the issue of the PKTT, now I think it is in recommendation 15.4.7 where there's a general or even abstract format that calls for you know, the review of specialized task teams. Our view is that we were dealing specifically with the PKTT during the Ad Hoc Committee, and our recommendation is clearly on the PKTT in terms of the auditing of its finances. So we would not want it to be just a general recommendation in that regard. We are recommending that the finances of the PKTT be audited, and then the Portfolio Committee on Police then be provided with that audited report once it is done. On the issue of executive powers versus operational powers, again, the recommendation we had made was quite specific, in which case we were calling for the Public Service Commission as well as the State Law Advisor to tighten the distinction between ministerial powers versus operational encroachment or operational directives, in which case we think that a very clear direction must be given in that regard. The current report, I think it's at 15.3.1, speaks about amendment of the SAPS Act, which, as we all know, could take a bit of time to do that. Hence, then we were proposing that in the meantime, at least some authority is established in that regard. Then on the issue, Chair, I'm just looking, Honorable Nhlanhla will also come in. So I've already spoken to, when I was speaking about an example on the allegations of members of parliament being in possession of classified information. We disagree with the finding in the report that the evidence did not support a notion that the information was classified, because we do believe that that General Khumalo in particular testified to the fact that that information was classified. We had come to a finding as the ANC, which we had deposited for consideration of the committee, that both Honorable Adams and Honorable Collar Barnard, we never investigated the source from which they received that information, and we think that the matter warrants further investigation. And as I said, that there should be a referral to the relevant bodies there, in which case the Ethics Committee of Parliament as well as the JSCI we thought were the relevant bodies. Sorry, Chairperson. Then the next one was on the Secret Service account of criminal intelligence. We had made a recommendation, firstly, that the state should, on criminal intelligence instability and vetting capacity, firstly, we had recommended that the state should establish an independent security vetting and integrity testing agency. The reliance on SAPS itself as well as SIU, we found that during the proceedings seemed to be slowing down the process, and therefore there should be a standalone security vetting and integrity testing agency. That has not been included, and we would wish to raise that matter again for consideration. And then we also asked that there must be an explicit independent forensic investigation into the SAP Secret Service account. And in that regard, that the reporting or the accounting for the Secret Service account should fall within one body. And in this case, we had proposed the JSCI instead of being split between police as well as JSCI, given the fact that sometimes issues between the two are not able to be seen, and police in particular does not have line of sight of all the items. Chairperson, can I stop there because my voice is failing me, and maybe check if Honorable Nhlanhla could please come in on the rest of the issues.
Thank you so much. Let me do this. Let me take Honorable Malema. Like I said, Honorable Malema, followed by Honorable Malema. And then I will come back to you, Honorable. Honorable Malema. Honorable Mnwango.
Chair, thank you. I thought Honorable Mates is here to respond.
Yeah.
So
Chair?
when you say Honorable Malema, I thought she understand you mean EFF.
No, I had recognized you because you had apologized that you were going to leave at 12. So I wanted to give you the benefit so that you don't speak when you are under pressure, like what we did with Honorable Sangoni, because he also requested to be released at 12, as well as Honorable. But if you
No, Honorable Mates will deal with that issue.
if you surrender all your rights to Honorable Mates, because she has just arrived, we are going to allow her to settle. And for now, we will take Honorable Mnwango, followed by Honorable Nhlanhla.
No problem, thanks.
Thank you so much. Honorable Mnwango.
Well, thank you, Honorable Chairperson and colleagues. Well, so far there isn't actually any substantial, issue that we would like to raise in respect of what we had actually submitted. We feel that the issues that we raised and recommended on are sufficiently covered. Honorable Chairperson. But we will actually come back if we feel that there are some issues that we would need to tighten up when that opportunity arises. Thanks, Honorable Chairperson.
Okay, thank you so much. Honorable Nhlanhla.
Thank you so much, Chair. Chair, I'm also down with flow. I think let me take from where Honorable Sangoni left. I think a part of what we had raised in the last meeting is the issue of the coordination of the law enforcement agencies so that they eliminate duplications where necessary. Another issue, Chair, that would have raised is an issue of IPID that should recruit and train investigators independently from the Hawks and SAPS. that the Portfolio Committee on Justice should also look at the NPA Act, specifically Section 27 that deals with the referrals to IDEC. We have said the crime intelligence must also investigate the circumstances that has led to Mr. Adams having an intelligence information. There must be a further investigation into how did such kind of information get leaked in the manner that it did. We've also said, Chair, that Patricia Mashele must also be investigated on how they coordinated and shared information that was not supposed to have been handled by them. Also, Chair, I think Honorable Sanguli has also spoken about the vetting process of crime intelligence officers, which may be the cause why, to a certain extent, some of the information get leaked. So there must be an extensive vetting of crime intelligence officers. I think, Chair, we have said also we in respect, I think Honorable Sangoni did touch in respect of the directive of the 31st of December that it was for the best interest of the ministry to issue a directive in respect of securing our borders. But we think the minister misconstrued his powers on the issue relating to filling vacancies and crime intelligence and the issue relating to the dissolution of the PKTT. There is an issue, Chair, that we raise also, which revolves around the accountability of crime intelligence that needs to be relooked, because the issue that the fact that crime intelligence reports in the JSCI and the Portfolio Committee of Police can also cause some accountability confusion, which has led to some of the members asking questions that would have best been accounted for in the JSCI, but asking those questions as members of the Portfolio Committee on the Police. Also, Chair, we have raised that the Minister of Finance, the Minister of Police, and the Minister responsible for State Security should discuss the possible amendments to Secret Service Act, which is an apartheid era legislation that enables the setting up of special account for funds used for secret services, and consider how its audit and accountability can be strengthened and brought in line with the overarching legislation and the values of the Constitution. Also, Chair, have raised the issue that the National Assembly must expedite the processing of the Protection of Information Bill, which has been with the National Assembly for quite some time now. Yes, I think those are the issues that, okay, we're saying, Chair. Okay, Chair. I'll come back again for other further issues. Thank you for now.
Yeah. I have said that the flu is a common occurrence in winter. It must not put you under pressure to a point where you threaten yourself thinking that you are sick. It's just a normal way that is slipping across, and then it too shall come to pass. So in case you may have any other matter that you may want to come back, you can always alert the chair. And yourself, Honorable Sangoni, Honorable Malema, and Honorable Mwango, your time comes and you feel you want to leave, and there is something that has come up, you want to raise it with the meeting before you leave, you are always welcome. Can I move to, before the DA, let me check if honorable members from the MKP would have arrived. Good morning, Honorable Skosana.
Good morning, Chair.
Yeah, thank you so much. You are welcome. When we started, you were not here. And
Yes, but I've logged in, Chair, but I could not say anything to say I'm already in. I thought you can see that on your phone.
Yeah, the chairperson wants to give you time to speak now, but because I'm a benevolent chair, I may have to check with you first if you are ready or you want us to take one or two more rounds before we come to you.
No, I'm ready, Chair. We can start.
We're on an item where we're making observations on the additions that members would have made in the last meeting, physical meeting, and the written submissions that they have made. In case there is anything that you would have submitted and you feel that is missing in the report, or it is captured in a way that you may need it to be strengthened, you are allowed to do so. And I have also said that because we are likely to finalize this report, the final draft of which will still be made available to members after the meeting, before it is sent out. If you may want to reflect on other sections, even those that we would have dealt with previously, the chair allows you to do so. It's your time, Honorable Skosana.
Thank you, Chair. I think some of the things which we've made inputs are not captured at all, Chair. I'm just going to give you a simple one. 13.6.14, Minister Mkhwanazi relationship with Mr. Mkhwanazi. We made it very clear that Minister Mkhwanazi initially had a public denial, on the minimization of his associate with Mr. Mkhwanazi, which is difficult to reconcile with the longer political association and regular communication subsequently acknowledged. The evidence support the concerns that the parliament was not given a complete or accurate account of the relationship when the issue was first raised with him. And that is not captured. If you go on that, our submission from A to D, it's not captured at all. In fact, when I read this today, I must say that I'm disappointed to say that the least that what I'm seeing here, Chair, I'm just going to be short for this round. I'll come back at a later stage. But let me just go back to the slide. In fact, everyone here is exonerated, Chair. Let me put it like that. This report, everyone is exonerated here. Well, we'll discuss it later, Chair. But what I can tell you, I've read this, and I'm seeing, on individual matters likely to require some deliberation. I don't know which deliberation. We've deliberated, Chair. Unless we are going to start afresh, in my view. I mean, starting when one has to start there, Minister Mkhwanazi directive, Mkhwanazi relationship, executive accountability, and its limits of evidence is the one which I was talking about now. To say the issue of the relationship between Minister Mkhwanazi and Mr. Mkhwanazi and Minister Mkhwanazi, Chair, I don't know if we say that there's nothing, there's no evidence on that. I don't know then what we are talking about. Then I was sitting in a wrong committee. The issue of the directive of General Sibia about these dockets between himself, Mkhwanazi, and Nhlanhla, and alleged false affidavit about the Rolex issue. We deliberated those issues. The issue of the person, General Masemula, who's now being charged, who's for a PMFA. The issue of accountability about the contract of Ket Nhlanhla, that we are still going to deliberate that. I mean, all the names here, in my view, in my view, I must put it like that. And as Umkhonto is a party, I'm shocked, Chair, that this report, it's like that we are not discussing anything. We still have to deliberate issues. I mean, we've spoken about all these men and women here, but it looks like we are going back, Chair, here. The issue of IDEC as well. When you go to that slide, that the judicially, procedurally, or IDEC capture, the report identifies and institutionalized risk and safeguard required, but does not make any concluded capture findings against institutions or named officials. No, Chair, I disagree. We made our input. We have deliberated in the Ad Hoc Committee for months. Now, if we are still saying all these things here, non-adopted or moderate views, institutionalized claims, I'm singling out IDEC. I'm singling out IDEC here. It can't be true. We know that we are not a court. That we know. And as I said, there'll always be a dissenting views, and we'll dissent, Chair. We are within our right. Where we don't agree, we won't agree, Chair. But anyway, it doesn't mean that if you don't agree, then therefore there won't be any finding. But it must be recorded that you had a formal dissenting views. The issue for instance, I think Honorable Nhlanhla raised the issue of Mashale. Commissioner Julius Mkhwanazi, the report does not make any criminal or disciplinary findings, but supports verification of existing investigation or complaints. I don't know what does that mean. Major General Khan, the report records that his absence limits the committee ability to resolve allegations concerning him. No adverse finding is made. I'm not going to say anything there, Chair, because I've said it. Mr. O'Sullivan and Mr. The report records concern about private investigation conduct and access to information. Specific matters are referred to only where capable of verification. I went to that report, and I think if one goes deeper into that report, much as I'm sorry. I'll come back to it. Thank you.
Well, Honorable Skosana.
Yes, I'll come back later, Chair. It's fine. Thank you, Chair.
Yeah. When you come back, if you have observed what Honorable Sangoni and Honorable Nhlanhla have done, at the time you come back, you should do not criticize this report. This is your report. What you need to do is to enrich it and polish it in such a way that it will reflect your views as a committee. So where there would be findings or recommendations where the report falls short of the committee's expectations, the members must then say, like, for instance, where you say, witness so and so, and then you feel that what is contained in the report needs to be strengthened. You make those recommendations and say, on the following aspects of testimonies by the witnesses, I'm suggesting that this is what, or this is how the report should be written. So you will have that time, and when you come back, please help us with such inputs. Honorable Breitenbach.
Thank you, Chair. Honorable Breitenbach asked that she had to pop out quickly. So if it's okay, Chair, I'll give the feedback from our side. I think firstly, I want to say that I think the report is quite comprehensive. I think it's very difficult to rehash everything on a virtual platform. And even though we've had so many meetings, it might be necessary for us to again spend some time in an in-person meeting and then do the final deliberation and decide. I think in terms of the general balancing of the report, in our opinion, it's a balanced report. And then just in terms of the Honourable Kola Barnard specifically, something that I think may fall short that is important for that deliberation is the fact that, part of oversight means that you need to report information that concerns your specific responsibility to the relevant bodies for investigation. And in her case specifically, she did refer and sent information to the Inspector General of Intelligence. And that was during the time when there was no JSCI yet. So, I think the question needs to be asked, what else should she have done then? Because if there is no JCSI, it seems that the logical conclusion would have been to do exactly that, and that was to send the information to the IGI. And then I think, lastly, Chair, it's also important to understand, sorry, Chair, it broke up a little bit there, but to get clarity on that specific matter. I don't think there's anything major else from us. I just think we need to ensure that there's clarity, especially also, and I think it's a bit of a shame that the IGI report didn't come to the committee, and that we weren't able to consider that too, because I think it would have coloured in quite a lot of what wasn't discussed, and that we could have and desperately did need clarity on. Thank you, Chair.
Okay, thank you so much. Honorable Thopa.
Thank you, Chair. We're covered by our colleague.
Okay, Honorable Kola Barnard.
Thank you, Chair. I'm covered by my colleague.
Thank you so much. The DA speaks in one voice. Honorable Matthys.
Good morning, Chair, and good morning, colleagues. Our input under findings, so we're going to start off on page 306. 77. We've got 16 paragraphs that we'd just like to do input on that. And if you can just bear with me for a second, Chair, I just want to go to it. So it starts off on 377, which is paragraph 14.12.3. Oh, no, let's start off with page 367, Chair, and then it's paragraph 14.2.2. So this is a very watered down paragraph, and I think the evidence does establish that there was erosion in our criminal justice system. So it must be replaced. We must replace that there was disclosed evidence that there is an erosion, rather than saying that there were vulnerabilities that could have led to politically connected or criminal actors. I think it is established that there has been an erosion that allowed the system, or our criminal justice system, to be exploited. And I think that must come out more clearly, rather than us referring to it as vulnerabilities that could have led to the system being eroded. And then also on 14.2.3, we left out, we ended at the NPA, so we need to add the judiciary in on that as well. On the finding 2, which is 14.5, and it's page 368, that goes on to 369. It must be clear that the directive was irrational, and that paragraph does not capture that the directive that the minister issued was irrational. It's also just very watered down. And then we go to paragraph 14.5.4. That paragraph is also extremely watered down. It needs to be clear that the minister made the evidence demonstrates that. So this paragraph is dealing with the fact that the minister was entitled to receive complaints and representations concerning the PKTT. So we were talking particularly about the minister's evidence that he relied, or he considered Ms. Mary Diaz's evidence when he made a decision to disband. But this paragraph must be very clear. It must mention that it was Ms. Mary Diaz material that he said that he relied on as part of his decision making process, and that must come out clearly, because that paragraph does not capture it that way. And then the same applies to paragraph 14.5.5. The committee finds that the complaints and correspondence associated with Ms. Mary Diaz and Mrs. Nhlanhla were relevant matters for investigation and review. They were not without independent verification. I'm not sure, I'm a bit unsure what that means, that second sentence. And I think it needs, not I think, but it must be just clarified that the complaints that were submitted was not independently verified. And for the minister to make such a high-end a decision on disbandment based on an independent submissions from citizens was not a sound decision at all. So that needs to come out much more clearly in that paragraph. And then we move on to paragraph 14.6.2 that says the available evidence was insufficient to determine conclusively the PKTT's overall strategic impact. That's not correct. I think the evidence, and we must come out, there was sufficient evidence, and there was probably only one or two of witnesses that came before us that said the PKTT was insufficient or the cost, etc., was not, it did not justify what it is that they need to do. So either we delete that paragraph altogether, but to say that there was no available evidence, we had many high-ranking SAPS officials, and there was even a comparison to other teams, task teams that were there, and they gave us quite a comprehensive input in this regard. So there was evidence to support that it was an impactful operation. We do support the ANC, though, that there needs to be an audit on the finances of the PKTT in that regard. Then we move on to 14.8.3. Where they talk about the moratorium on the appointments in the crime intelligence. So the way it's worded, it's also very high end, and it says broadly framed. The moratorium was not broadly framed. It was very clear what needed to happen, and it must come out clear in this paragraph that it contributed to the existing instability, which is what we are saying. But we must say further erosion, because it wasn't just instability. When you just stop the appointment in the crime intelligence department that is already unstable, or was suffering high levels of instability, we were eroding that. So it needs to be very clear that decision, it was also a very irrational decision for the minister to make in that regard, and it's not coming out clearly. And as Honorable Kosana was saying, we've been taking a very high level approach and saying it may have, could have, but we couldn't have sat for so many months to come up with the report that says may have and could have, and we need to be very clear in that regard. On paragraph 14.9.3, it says here the committee did not receive a complete IGA and JSEI audit record. We didn't receive anything at all, and I think that must come out clear, unless we missed something. But we did not receive any evidence from the AGI and also from the Joint Standing Committee. So let's just be clear about that, which we also brought up in the previous meeting. And then we move on to paragraph 14.12.3, which is page 377. And this is in relation to the Minister Mkhunu and Mkhwanazi and Matala's relationship. And it said it created a reasonable appearance and risk, and that resulted. This is not what we sat through all these months to say that it created a reasonable appearance. It was an improper influence because of what was involved, and that must be clearly stated. It must be clearly stated in this paragraph, not a reasonable appearance. It wasn't an appearance, it was an improper influence in that regard. And that's our input on there. And also on 14.12.5, this is also on Mr. Nhlanhla's approaching the senior officials concerning the facilities and that Medicare 24 tender. This paragraph must be reworked. It did not create a risk. It was an improper and it was an irregular influence on SAPS officials. And we knew that those SAPS officials came and they explained, some got birthday presents, etc., and attended parties, etc. So their names must also be listed here, and it must be stated that it was an irregular and it was an improper influence. We can't say that it appeared to be in that regard. The same when we move on to paragraph 14.12.6, which is page 378. And this is dealing with the relationship. You know, this whole report in regards to Mr. O'Sullivan, Sarah Drayton-Trent, and Robert McBride is extremely watered down. So I'm going to start off with paragraph 14.12.6. And this must be reworded to clearly state that the relationship that was between the then IPED director, Robert McBride, O'Sullivan, and Trent, it was improper and it was irregular and it warrants criminal investigations. And then obviously that must be one of our recommendations obviously I think there are cases that are currently open in this regard, but our report must also be given to them that we found that the relationship was improper, it was irregular, and it warrants criminal investigations, and that's exactly what must be done. And then on the paragraph of 14.12.7, and this was the communication that Honourable Sauls reported to the committee in the presence of Mr. O'Sullivan, that he had sent him a message the previous night, from what I understand. So we can't write here that alleged contact between. It wasn't, he didn't deny it, and this whole paragraph must be reworded to state that that is what is exactly what happened, and it must be referred to the Speaker's office, because we can't say that it requires further assessment. It doesn't. It was there. We all saw it. We all heard it. He was there. And it must be clear that there must be action taken against him sending those messages to Honourable O'Sullivan, Honourable Sauls, rather to do that. Also, the whole matter of our engagement with Paul O'Sullivan is not properly captured in this report. And while I do appreciate that we can't capture or include everything, we have put our recommendations forward, and none of the committee members has rejected that. That from our very first engagement with Paul O'Sullivan, it must be here, and the extent that we had to go to, including his walkout, and his name must be mentioned here very, very clearly, including the accommodation and all those requests that he made, how he walked out, also how he insulted one of our honourable members here in the committee. That must be captured in the report, and not as a high end. It can't be that we can let people off the hook in that regard who showed such utter disrespect to the process of this committee. So that must be, and we can't keep telling the content team to capture this, and we keep getting back a very watered down approach. One of our honourable colleagues spent a lot of time in our physical meeting on this matter of Paul O'Sullivan, and we come back and it's a very high-ended description here, where if they could avoid mentioning his name, it's not mentioned. So our report must clearly capture, and it must never ever happen again that Parliament can be disregarded in that way. And it must state that the criminal case that has been opened as well, and that must also be part of our recommendations, that we follow up and that we get regular reports on the criminal case that was reported to him. Subsequently, also one of our honourable members put in that he had sent another message to him after our deliberations. So we must also look at how we're going to capture that in our report, and perhaps also this must be referred to the Speaker's office, that it might be also added to the existing case that we had. It can't be that man can just run around this country and treat Parliament in the manner that he has. And then we move on to paragraph 14.3.2, and this is that the committee does not find sufficient evidence to support or to identify the big five. I think the last sentence in this regard that says such allegations require independent investigation. Independent, what do we mean by independent? It requires a high-level criminal investigation, and that is exactly what it must say. Once we say independent, we mean independent from what? So this is a matter for SAPS or one of those criminal justice departments to deal with. So that must be properly captured. And then we move on to 14.4.2, and this paragraph is also dealing with the issue of Paul O'Sullivan and Sarah Jane Trent, and them being private investigators. This is also a very watered down paragraph, and the submissions that we gave, it must be clear, their names must be mentioned here. The name of that company that they work with, that is registered, I think it's Forensic, I can't think of the name offhand, and I haven't, or it's not captured here in my notes. But it must be captured here, and it must be reworked that we are referring to Paul O'Sullivan and Sarah Jane Trent in this regard. And it must clearly capture their involvement with policing functions, particularly in IPAD, and that it warrants irregular an improper relationship, and it also warrants criminal investigations. This paragraph is way too watered down to deal with the evidence that we heard before the committee. And then on paragraph 14.5, this paragraph is dealing with the equipment, and it's talking about our borders. And our honourable colleague also dealt with that, on that everyone who works on our borders must be properly vetted even before they go there, and we support that. Beyond that, The report currently states that the committee does not find that a particular equipment deficit. It's not true. The committee finds that there's not a single person who was asked about the committee said that there was sufficient scanners and other equipment for us to be able to have better control at our ports of entry or our borders. I don't know if ports of entry is the same as borders, because ports generally refer to the sea. So, but we'll be guided by the content team in that regard. So we need to replace this, that the committee finds that there is deficient scanners and other necessary equipment at our border posts. Lieutenant General Mkhwanazi was very clear. I think he said that there was only one scanner in the whole of the country to scan, and that covers scanning drugs and even human trafficking. And there's nobody that disputed that matter. So this must be clearly captured, that there isn't sufficient, and this deficiency of equipment and scanners does contribute to the high level of crime that we are experiencing at our borders. And that is a finding that we can make very clearly. We move on to, I'm not going to cover those that have already been covered. Under President Cyril Ramaphosa, paragraph 14.21.15. And that paragraph is, it must be reworked because it doesn't adequately capture that President Ramaphosa didn't immediately attend or address the matter that was referred to. And here we are talking about the report from the minister on the directive of disbanding the PKTT, etc. So when you read the paragraph, it's there. So it should be reworked to say that that the president, he did not immediately attend or address this matter, and he also allowed it to spiral, and as the result, it also eroded public confidence in the matter. We also need to insert a paragraph here as well that is not captured, is that there's no evidence before the committee that President Ramaphosa dealt with the protected disclosure that was addressed to him by a high-ranking SAPS official, Lieutenant General Vuma, at that time. And it included very serious allegations against senior SAPS officials and also the minister of that time, Minister Cele. And the fact that the disclosure was not duly processed, it also contributed to the very prolonged suspension of Vuma. And she was on paid suspension right until she retired. And that should be clearly captured in the report or as a finding as well. And then on paragraph 14.21.22, and that's on page 391, we have there that Lieutenant General Mosikile's failure as acting minister to obtain legal advice or issue a sufficiently clear written command protecting active and court ongoing matters raises, and it says limited command accountability. We must not downplay this. We must just delete that word limited and just say that it raises command accountability concerns. And then we move on. I hope I'm going to wrap up very soon. Page 393 onto 394, which is paragraph 14.21.35. And this is regarding Mr. Mkhwanazi's separate allegations concerning his cash payments. Cash payments, interventions, and access were denied and remain unproved. They are serious allegations. Here again, the word independent is used, and it warrants independent investigation. That must also criminal. We must replace it with criminal investigations, and we support that that we find the committee makes no findings of bribery or corruption. But I really don't think that's necessary because we can't make a finding in that regard anyway. But we are making a recommendation that it warrants a criminal investigation, and that must be clearly captured. And that applies same to under Mr. Paul O'Sullivan under paragraph 14.21.37. It also says that the complaints warrant independent, so we must replace that with criminal. And this is in regard to Mr. O'Sullivan captured iPad and impersonated iPad official. From what we understand, this matter is still, or it's under investigation by one of our criminal justice departments. But this is also something for Parliament and the Police Committee to follow up and get regular updates. And that also applies to Sarah Jane Trent in the same regard of the impersonation, that it must warrant that. We gave input quite in depth in regards to 14.21.29. Just after that, we need to the conflicting testimony between Ms. Mary or Sarah Jane Trent and Mr. Robert McBride regarding their personal relationship, sexual relationship. I don't know what would be the correct term that we use here. But that is a matter of a case, and a case of perjury must be open, and we allow the department, the SAPS, to do that investigation. But we can't have anybody appear before Parliament and blatantly give conflicting testimony, and then we come here in our report and we give a very, very high level that it must be sent. We must do an assessment of the testimonies that were before us, etc. And while we did give input in that regard as the EFF, that we do that, this is very clear that that is what had happened. So this matter must be referred also to the Speaker's office. So that case must be opened against them, and then obviously the Police Committee needs to follow up. We also need to insert a paragraph. We don't have, not a paragraph, but we don't have a heading for Mr. Robert McBride here. And that must be done. And in that paragraph, we must highlight that he had an irregular and an improper relationship. And that's what the committee has found with these two so-called private investigators called Ms. Mary Jane Trent and Robert McBride. And then also a finding against him on that the possibility that he committed perjury, given the conflicting statements between him and Sarah Jane Trent. And then on paragraph 14.21.41, this is regarding the evidence of Mrs. Vuma, and it says here the evidence does not establish every allegation contained in her protected disclosure or every allegation made against her, against the persons made. So that we agree with. And it says it does establish that the state was unable to demonstrate a coordinated, properly documented and complete response to the disclosure. So that was our input, that there was no action. We have no evidence in the committee to say that her disclosure was acted on. But it's not the state. In particular, we must put in there President Ramaphosa. That disclosure was addressed directly. He was the first person that this was directed to. And if I'm not mistaken, it goes back to 2022. So using the word state, we must replace that with President Ramaphosa and the other respondents, recipients rather, that she sent it to. And then we support the input on Honourable Collard Barnard, which is paragraph 14.21.44. And then we move on to Advocate Andrea Johnson. This is also something that is very watered down on her testimony. After 14.21.47, we need to say clearly here, we need to insert a paragraph here that says that we find that Advocate Johnson did not provide, she did not give us, even up to this very moment, we do not have the section 27 in relation to the Honourable Adams matter. And both of them actually said that that was going to be submitted, and we haven't done that. So that must be a very clear finding in that regard. And it also warrants further investigation. And this must be referred to the the IDEX oversight body that is now fully operational as well in regards to the Section 27. And in our submissions, we made this very clear, but it hasn't come out very clear in this draft of the preliminary report. Then on Mrs. Mary Diaz, paragraph 14.21.48. I know some of these matters might seem a bit trivial, but we need to set a standard in Parliament that we can't be treated as that we are running a shebeen and people just come and they can even be information peddlers, and we allow that to happen. So this paragraph currently reads that the committee finds that references to Ms. Diaz as a professor were inaccurate and an honorary degree. We don't have a copy. There's no evidence before the committee that she has earned an honorary degree, and we don't even know from where. So where that information comes from, I don't know. So maybe we can be guided, but not even she told us during the hearings, from what I understand, that she had an honorary degree. So this must be corrected because there's no evidence that should be said in that regard. The way this paragraph is written, it's really just trying to maintain some sort of balance on Miss Mary Diaz, that while she might not have had an earned degree, she had honorary, we don't know. And also the last sentence that says the evidence does not establish that she deliberately misrepresented her qualifications. It's not true. Ms. Diaz, the whole time when she started, we were referring to her as professor. She writes articles in newspapers, she does interviews, they call her professor. She has never ever corrected anybody, including us in the committee. It was only when the EFF asked her about her professorship did she say she did not have one. I don't even think she had concluded her master's degree, if I'm clear. So this whole paragraph must be very clear that it was deliberate and that she had misled the committee until she was asked how and where did she earn her doctorate to be referred to as professor. And then the same thing on 14.21.49. Her long-standing research and violence monitoring experience, there's no evidence except that she told us. So that is very incorrect to say that she has some long-standing research. If anything, the evidence of what she presented to us can actually be equivalent to her just being an information peddler. Because one of the honorable members even asked her, how do you verify? And she said that she doesn't verify, she just gets information. Next minute she's writing articles, she's writing letters to everybody, like all the information that she has done has been verified. So this must come out very clearly, and this paragraph must be reworked, that there's no evidence before the committee that supports that she did any credible research violence monitoring. There isn't. And we can't put that in there, that she has a long-standing research. We don't know. And she couldn't even tell us where she gets that information as well. And I think that concludes it on our input on the findings. And then we're almost done here. Just on the recommendations, when we start on, which is going to be page 401, which is 15.2.1, the National Assembly should request Cabinet to mandate. Actually, no, we don't need to address that. That has been sorted. Chair, bear with me. We're about to be done. Because this, on the recommendations, it just feeds to some of the inputs that we made on the findings. So 15.6.14, which is the intelligence reform, the National Assembly should request Cabinet to mandate the minister responsible for state security to assess. So we long past this issue of assessing. It's like the committee, it means that we didn't do any work if we are going to refer matters to be assessed again. There's no need for assessment. It's clear that there needs to be an urgent solution and implementation. And that's not just for this paragraph. There's quite a number of reforms that we are recommending here, and we use the word review and assess way too many times. And if we're going to move in that direction, we've wasted all the months of work that we've done. So there's no need for reviewing and assessing. There needs to be action, and we must state clearly, which we do capture, I must say, in the preliminary report on what that should do in terms of revising, whether it's regulations or legislation in particular in that regard. But this thing of assessment and review is extremely unnecessary, and it renders this committee very useless if we're going to go in that regard. And then if we just move to page 417, 15.8.4, and this is in regards to the letter that Lieutenant General Mkhwanazi submitted on Jeremiah Pym letter. This is also a very high level paragraph, and it needs to be clearly stated that that whole letter and what it is that is said must be referred to the relevant authorities, including the Inspectorate for Correctional Services. It's too high level, and we must say exactly what the referral is and what is it regarding, and they must receive the letter, because he's made very serious allegations on who was getting in and out, etc. from there. So that paragraph must be very clear what it is we are doing and why we are saying that the Inspectorate for Correctional Services must be involved in that regard. And then I think you're going to be very happy, Chair, because I am, or we are done. The same thing with 15.14.2, which is page 428. We've also used the word review steps, disciplinary and consequence management. There's no need for a review. It needs to be amended to deal with these issues, especially the ones of this prolonged suspensions on full pay, and they must come and report. But that goes pretty much along with most of those paragraphs where we say review and assess. So there must be amendments that must be done, that must be properly aligned to deal with the findings that we have made in the committee. And I am on. Just bear with me, Chair. Okay, and I think this is on page 441. This comes back to the Paul O'Sullivan and Sarah Jane Trent, which is paragraph 15.16.28. I addressed this in the beginning also as well, so I think the content team has gotten it. The Paul O'Sullivan matter is not adequately captured here in this, and this includes in the paragraph of 15.16.28. So on this matter, we must also open that it must state also we've opened a criminal case, and perhaps the content team might just want to deal with Paul O'Sullivan and his entire shenanigans and contempt of Parliament in here. It must be captured. It must be captured clearly. His name must be mentioned, and every single thing that he does. We do not want a high-level report on what it is that he did in undermining one of the three institutions of the state. Also on 15.16.31, where we said that the National Credit Regulator must deal with that issue on how both him and Sarah Paula Sullivan and Trent accessed citizens' information without their consent. But we also went further here, and we said that that organization in which they are members of, it must also be the operations that are here in South Africa must also be investigated. It can't be that they can be members and be members of an organization. They pay membership fees, and this gives them access, because that was the link on how they get access to all this information. So that organization's name must be clearly written here, and that they must be also investigated by both the information regulator and the national credit regulator as well. And we've dealt with on page 448. 15.16.57, but I addressed it earlier on the perjury case that must be opened by Parliament, Trent and McBride, in regards to their contradictory testimony before the committee. And that concludes our input from the Economic Freedom Fighters. Chair, long live the EFF. It's our 13th anniversary this month, just saying.
Thank you so much, Honorable Matthys. Once again, let me check with Honorables Sangone, Malema, and Mwango if there is anything they want to say before they leave. Honorable Sangone?
No, nothing from me at this point, Chair. Thank you.
Okay. Honorable Malema? Honorable Mwango?
Well, nothing from me so far, Honorable Chairperson.
Thank you so much. We are now going to proceed to the Patriotic Alliance. Honorable Sols.
Chair, good morning.
Good morning to you, Honorable Sols.
Yeah, Chair, I am on the road, so I gave an apology, but it's a bit of a struggle for me. But I'm just stationary now to make some submissions, if that's okay.
Yes, you are welcome.
Okay, thank you, Chair. So, firstly, I know you've rotated already, I'm told, but I missed that portion. So, if I'm out, just bear with me, Chair. But I just want to make my submissions.
The rotation is now at your station.
Oh, okay. The green station. All right. Thank you, Chair.
Okay.
Chairperson, I have a deep concern when reading through the report, especially the party contributions and how it is framed and how it is listed. So before I considered it just as a matter of perhaps context or wording, and then I just would obviously, as you know, just highlight and emphasize that our position as the Patriotic Alliance. I think Honorable Barnett is live there.
Just hold a moment, Honorable Sols, so that we... Honorable Barnett. Honorable Kola Barnett. Okay, I know she has muted. Honorable Sols, you can proceed.
Thank you, Chair. So usually I would just make comments to say, to emphasize that the Patriotic Alliance contributions is not one-sided. It's emphasizing another side so that there is balance, but it shouldn't be misconstrued as having chosen a side. And therefore, because my colleagues are raising already elements of other witnesses, so it will be disingenuous for the Patriotic Alliance to repeat those, but rather zoom into what is not mentioned and what is not zoomed into, which is usually the other side, which is not the popular side. So because the Patriotic Alliance is committed to a balanced approach to uphold the integrity of this committee, we would then zoom into the other side. And then hopefully, because we are doing it as a committee, although the recent trend has shown that now in public comments, different parties are isolating themselves from what the committee work is and so on, which is incorrect in our view. But we won't do the same. We will still take it as it's the committee work. So when the Patriotic Alliance contributes from one side, we are hoping that the report would then put it all together and then highlight the position as a committee position in a balanced approach. But unfortunately, Chair, when looking at especially the party contributions, we are misconstrued. We are put forward as though we are dealing with only one side. So I want to make one thing absolutely and unequivocally clear for the record. And I want this captured word for word so that there is no misinterpretation down the line. The Patriotic Alliance is not here to play factional politics, nor are we here to protect individual personalities. From day one, my mandate has been single-minded. The truth, the whole truth, and nothing but the truth. And a single, uncompromised standard of evidence for everyone who sits in front of us. Yet when I look at how our submissions are being chopped up and compartmentalized in these drafts, it screams an attempt to twist our words. The report, especially the party contributions, it seems to be framing the Patriotic Alliance call for evidentiary balance as if we are choosing sides. This is incorrect. It is making it look like we are attacking one general to shield another, or defending one minister to undermine another. Now, I will not allow it. I will not let this report weaponize the PA's commitment to fairness to fit a preconceived narrative. So let me set the record straight, clearly now. When we call for Lieutenant General Mkhwanazi's retracted allegations and flawed digital analysis to be scrutinized, we are not targeting him. We are stating that hearsay cannot be treated as holy scripture. The same way we rightfully celebrate the media briefing on the 6th of July, we are saying we must equally not victimize other whistleblowers who also used social media to expose the rot in SAPS, especially when it was tested thereafter and found to be true. So our position is simple, Chair, and it is a rule of law, an equal standard of testing for all allegations across all witnesses without exception. But if this committee insists on applying a selective, uneven standard of credibility, where some witnesses get a free pass and others hung out to dry on untested claims, they can do so. But do not use the name of the Patriotic Alliance to legitimize it. We stand for equal testing, equal fairness, and absolute accountability. Anything less is a disservice to the public. And I will not have my name or my great party's name associated with it. I wanted to make that statement, Chairperson, and then make some contributions on the findings, and then I will rest, Chairperson. So on number one, as we move to findings, I think we'll just deal with findings 1 to 4 for now. And again, pushing for the wording to really emphasize a balanced approach. So the original draft focuses heavily on the deficiency of the directive's initial issuance. So to establish balance, I think the finding must reflect that SAP's operational leadership actively intervened, the top brass actively intervened, because we heard about the meetings that was held thereafter, and it was decided on a winding down process so as to protect active dockets and court cases. So The current wording reads in finding 1, the evidence disclosed systematic governance weaknesses, not only an isolated administrative dispute. We would like to recommend the following wording in a balanced way. That the finding 1, the evidence disclosed systematic governance weaknesses across both the executive authority and operational command structures, highlighting a mutual failure to maintain clear formal boundaries in policing. Because that's what we found. We found it on both sides. Finding 2, the 31st December, this is the current wording, the 31st December 2024 directive was issued and implemented through a materially deficient governance process. We feel that finding 2 should read, the 31st December 2024 directive was formulated through a deficient process. Fact, right? However, subsequent operational interventions by SEP's command established a managed, structured winding down process to safeguard active docket continuity, witness protection, and court-enrolled cases. That's what we found. Under crime intelligence, procurement, and influence, let's look at findings 5 to 6. Finding 5 reads, crime intelligence is affected by serious structural and integrity vulnerabilities. We propose finding 5 to read, crime intelligence is affected by serious structural vulnerabilities exacerbated by a lack of rigorous verification protocols for internal data and analytical reporting. We saw that before our eyes in the committee hearings. Finding 9, informal influence and improperly managed relationships created institutional integrity risks. Finding 9, although it appears to be short, concise, and straight to the point, I think it's a bit vague. So we propose finding 9 to read, improperly managed relationships and untested allegations created integrity risks. However, the committee notes that key allegations, including claims of corrupt payments, were formally retracted due to fundamental errors in data analysis. We found that, and it's a great risk to the integrity of our processes. Almost done. Finding 10, while vulnerability to organized crime exists, the evidence does not support sweeping claims of institutional capture or cartel control. The committee cautions against elevating unverified rhetoric to institutional findings. That is how we believe finding 10 should be worded in a balanced approach. Currently, it just reads, serious vulnerability to organized crime influence was disclosed, but not a single controlling cartel. We feel that it should just be expanded a bit as I just read it. Then, lastly, Chairperson, I would like to propose an additional finding, finding 11, to read, to protect institutional integrity, all witnesses and whistleblowers must be subjected to an equal standard of credibility assessment, and no untested or retracted hearsay shall form the basis of adverse findings. So in this way, it formally embeds the equal standard of testing, rule directly into the committee's final conclusions. I so submit, Honorable Chairperson. Thank you very much.
Thank you so much, Honorable Sols. May we move to Honorable Bethel.
Thank you very much, Chairperson. Chair, I was not present, unfortunately, in the previous meetings where the draft report was deliberated, and I will thus not burden the meeting now. I can live with the majority of findings and recommendations. It is a comprehensive report, and I think overall the findings and recommendations are quite fair. But I do agree with other colleagues that stronger and more unambiguous language is necessary in many instances, as alluded to by especially Honorable Matthys. I do also agree with the ANC's proposal in terms of legislative reforms, as they alluded to. And with a lot of the other inputs made, especially by the Honorable Matthys, I think it's necessary for the content team to respond and also give their rationale for the wording as it is currently, and explanations as to why it's not as the Honourable Matthys and other colleagues suggested. I think it's necessary that we evaluate the reasoning behind the content team's formulations, and that we can then make final determinations in that regard. But overall, that's my input. Thank you, Chair.
Thank you so much, Honorable Vessels. Honorable James.
Thank you so much, Chair. Please just bear with me. I'm just recovering with flu and a bit of a chest problem. But I'm going to try my best to make our submission, Chair. Having listened and agreeing with the input from other members, Action SA makes the submission to place on record its position on how the committee should deliberate on the evidence before it, and to register its serious concern that the draft report in its current form does really not reflect the evidence laid before this committee. We ask that the submission be recorded in the minutes and considered before the committee adopts any findings, right? Deliberations must proceed, and I think we've said this before, deliberations should have been and must proceed on a line-by-line basis. Action SA calls for the committee's deliberation on the evidence and the draft report to be conducted in exactly the same manner that we did the terms of reference were deliberated on. It was done line by line, clause by clause. The terms of reference were adopted only after each provision was interrogated, tested, and agreed by all the members. This report is a document of far greater consequence. It sets out the committee's findings on serious allegations affecting the criminal justice system, and it will inform referrals to law enforcement and the prosecuting authorities. A document of this weight cannot be adopted like this in bulk by theme or by global vote or a pre-drafted text. Every finding and every omission must be tested against the evidence and agreed by the members individually and openly, a line-by-line process.
Honorable James, just a moment.
Okay.
Just to remind you, we are not adopting the report. What you are suggesting is what we will come and do on the days that we will be going through the report for adoption. You are making a valid point that has to be recorded, so that when we, maybe after 2 or 3 weeks, when we will be adopting the report, the chair very, very much agrees with you that we need to be very diligent and very patient with the manner in which we deal with this report. Is of it's a report of high magnitude for the reformation of the criminal justice system in the country. I'm just saying that even now, as you emphasized the point, when we come back to deal with the adoption of the report in the coming weeks, you must never shy away to make emphasis on that point. Thank you. You may proceed.
Thank you, Chair. But I also just want to say that I'm just concerned that at this point, like all the members have expressed earlier, that sort of we don't have certainty of where our submissions find expression in the report. So sending it now, obviously, for the next 10 days, I almost feel as if though we've lost opportunities to go through this report. I mean, previously and even now, before we even go further, that we should now stop and almost like re-look at the report. I'm not sure if members will agree with me, but Action SA's position is that right now, this report, like Honorable Matei says, it feels it's been materially watered down. It softens, it definitely softens, and it omits findings that the evidence plainly supports. And in several respects, it reads as a summary of proceedings rather than a determination on the facts placed before this committee. And that is our concern at this point, Chair.
Yeah, this report is not going to be sent out without you seeing it. The observations that members are making today are going to be integrated in the report. And the final draft, which will be sent out to affected parties, you are going to satisfy yourselves first before it goes out that it is essentially what you have impressed upon.
I hear you, Chair.
Are you happy with that?
I'm happy with that, Chair, but I just request that I be allowed just to give further input with regards to our
Yes, no.
observations.
It is your time now.
Thank you, Chair. So, Chair, having said that, in particular, we note that where the oral and documentary evidence pointed to a clear conclusion, the draft retreats into sort of neutral language that does not commit the committee to a finding at all. The effect is that the report will not withstand scrutiny and will not produce the accountability this process was established to deliver. The remedy that I said earlier on, and maybe like you said, this should be left for when we deliberate on this, is the line by line deliberation set out above. Each of the passages should be revisited against the transcript and the exhibits and amended to reflect that which was actually established. The report must explicitly address perjury before the committee. Let me reflect on the evidence of Advocate Andrea Johnson. Action SA most serious concern right now is that the draft report fails to state explicitly that the evidence in our submission establishes that a witness gave evidence under oath before this committee, and that evidence was false, and that this conduct amounts to criminal wrongdoing. We refer specifically to the evidence of the head of IDAC. It is our position that the material aspects of a testimony under oath were contradicted by the documentary record, the evidence of the witnesses, subsequent disclosures placed before the committee, and that these were not peripheral matters, but went to the core of the allegations of the committee that the committee was mandated to investigate. Giving false evidence under oath before a committee of parliament is not merely a credibility issue, and this is why I say so much the wording here has been watered down. Is not a credibility issue to be noted in passing. It engages the powers, privileges, and immunities of Parliament and Provincial Legislators Act, and it is capable of constituting perjury, a report that records contradictions in Advocate Johnson's evidence, but sort of stops short of naming what those contradictions are, leaves the most serious matter before this committee unaddressed. Action SA also therefore calls on the committee to make an express finding that the evidence of Advocate Andrea Johnson was in material respects false and given under oath. This conduct constitutes possible perjury and possible contravention of the Powers and Privileges Act, and the matter be referred to the appropriate prosecuting authority for investigation and, where warranted, prosecution. A report that declines to say this plainly does not reflect the evidence and does not discharge the committee's duty to Parliament and to the public. What Action SA asks of this committee, respectfully so, request that the committee resolves to deliberate on the evidence and the draft report on a line-by-line basis, again, with each finding and recommendation put to members individually and recorded, revisit every passage where the draft departs from or sort of understates the evidence led, and amend it to reflect the record, and make an express finding on the false evidence given under oath before the committee, and refer that conduct for criminal investigation and possible prosecution. Action SA also remains committed to a report that is credible, defensible, and worthy of the seriousness of the allegations this committee was established to investigate. I'll leave it there. Thank you, Chair.
Thank you so much, Honorable James. The last speaker is Honorable Skosana. No, I mean Honorable Skosana, Honorable Thokanyile, and Honorable Ntuli.
Chair, is it me or Mr. Nduli?
You are all honorables. We are going to start. We are going to start with you, Jali.
Yeah.
And
thank you, Chair.
Followed by Honorable Sokanyile, and Honorable Ntuli will be the last.
Okay. Chair, as I was raising issues earlier about the report, that the report, if we have to produce a report like this, I can tell you for free, Chair, that we will have failed the people of this country. After working so hard and after spending so much time and so much money, it will be really a travesty of justice if really we produce a report like this, which is not really what we have uncovered. Now, when you look at this report, I'll take you through. I hope that I won't be long, but we've made our submission, and our submission was not captured as we wanted that report to reflect. And I've said it, the last time we met. I'll start on section 7 in terms of limitation on that report. That we must emphasize that the inquiry scope extends beyond SAPS. That the evidence includes claim of cartel infiltration across the criminal justice system. And remember that the draft should also incorporate the cross-sector concern, as we have proposed as Mkhwanazi says. And we have explained, that institutionalized disparities in the oversight. And when you go to section 10, the public participation. Now, as you've seen in the Nhlanhla Commission, the issue of Chetty, who we almost dismissed from him, giving evidence before us. Because I said it clearly that these are the people who write letters and send emails to us as members of the portfolio committee in police portfolio committees. He raised the issue as well about IDEC, the issue of the Indian cabal, and the issue of Andrew Johnson. The issue of Andrew Johnson and her team there, it must really reflect on that eventuary overview. The report must be updated to reflect the outstanding documentary evidence, like Honorable Mateus have said, because we asked for that, and we still don't have it. We still don't have it, and I think we must open a criminal case against Batoyi and Andrew Johnson. Because his testimony, I mean, what he said, all those relevant documents were not given up to now. And we said his agent, he said in two weeks' time. And similarity as well. We must note that those documents which are not submitted, and we agreed that is unacceptable, we as a committee, we agreed upon it, and that does not reflect this report which we have. We must ensure that all this public, on section 12, that the public hearing testimony are accurately summarized. You know, but as well, I think my colleague has raised that about the issue of Mrs. Dihas and Mashele. You know, I think those ones are the one which we have captured. And the issue of Sejen Mlotshwa as well is not captured into this report, because there were a lot of conflicting a statement from him and from General Mkhwanazi of what exactly happened to the person who by now has passed on, you know, and yeah, those have to be captured as well, and that's it must include the admissions that, you know, he instructed the covert recordings, that's Minister Mkhunu of General Mkhwanazi, and that he is misrepresented to Parliament, as I said earlier, when you gave me the chance earlier, that Minister Mkhunu, we cannot be told that there's no evidence about him and Brian Mkhotsi. And about, and the extent which he said he has spoken to the president. And we know now, when the president responded in writing about this directive of December 2024 on the 31st, we know now. If the draft is minimizing this point, no, then Chair, I really disagree. They should amend that for it to reflect exactly what we're told and what the response of the president and the response from the minister himself. And section 12, the draft as well should clearly state that General Khan was never called as a witness, despite numerous references in the evidence to his role. And I hate to say I'm vindicated, Chair, on the issue of General Khan. I'm going to say that again. His absence was noted by the evidence leaders as unresolved issue. This omission is embarrassing us today. Now we know, and we knew even before, but unfortunately there was this resistance of him appearing before us. And I said it clearly that we are not judging them. We want them to come before us. And I personally, I'm saying to you, Chair, it's not a secret. We almost, because we are serving in the portfolio committee, we almost speak to every general in the country, being provincially or at the head office. So he was not immune as well. And we called him to come. Unfortunately, he said he's going to Mecca. And I said to the secretary, you know, our secretary there is, unfortunately, we try our best, but be that as it may, I'm happy that at the Nhlanhla Commission, though we had our reservation about Nhlanhla, but a lot of things are happening there. And in fact, they are cleaning some of our shortfalls, because we're supposed to be the one who have summoned, even for that matter, General Khan. Now, likewise, Chair, the recommendation about vetting, strengthening the task team, clarifying the crime intelligence mandates as well has to be emphasized. And for us to introduce the oversight on judiciary or legislatively, I think the portfolio committee will do exactly that, because we all know now that the evidence should be retained and really expanded and not be the only end when we finish with our ad hoc committee report. Now, the section 1 to 6 on that preliminary scope and terms of reference. No specific MK inputs were submitted on the basic of introductory section on terms of reference. The draft background and the mandate statement appear sound, e.g., the establishing of the inquiry under Rule 169 1 following Mkhwanazi 6 July 2025 media briefing, because we noted that the evidence summarized the insert later, because we've seen that, you know, on what General Mkhwanazi submitted to us and what he explained when he appeared before us, which clarifies that the president affidavit explained he could not even could not establish the PKTT directly. We all know that. The draft structure should ensure the consistency with the evidence leaders. The executive summary, the president rule, the structure of the PKTT without factual error. For instance, Chair, any text suggestion that the president himself created the task team must be corrected and reflected that it was done by the interministerial committee on his behalf, but not by the president. And I think that should be clear on this report. The gaps which we have or the witness gaps, the draft must be recorded that Major General Feroz Khan, Crime Intelligence Deputy, was, I think I've dealt with that, Chair. Because Lieutenant General Mkhwanazi, namely the role of General Khan, has not been fully explored because of General Khan has not been called to testify. That alone, we have to make sure, Chair, that is covered, you know, and the language should be quoted as paraphrase, as expressed, you know, on caveat. Similarity in any pliant witness, e.g. of our honorable member, Ms. Kotle Barnard, on the in-camera witness to who possessed the classified evidence, should be mentioned under limitations if they were not heard. And I think Honorable Martins has raised that. I'm urging that these omissions be documented rather than closed over, Chair. And the issue here of Nhlanhla, if what I was reading this morning, I mean, what we have, what was submitted by the administration now, or the legal team. I won't say the legal team, I'll say the admin. The Molefe Maumela allegation, General Mkhwanazi named Katiso Molefe and Moken Maumela as a high-level syndicate members. It's not us who said that. The draft limitations finding should say that the alleged involvement of Ms. Molefe and Maumela was not tested in evidence. The evidence leaders' report shows that Mkhwanazi names do appear, but there's no confirming testimony on that. For example, Advocate Arenze summarized notes Mkhwanazi identified Ms. Maumela on 18 of March 2026. However, without cross-examination or supplementary evidence, this remains an allegation only. And we could have done better on that. But be that as it may, we are here now. We have to complete our report. But I want to propose that the witness allegations about the persons such as Katiso Molefe and Moken Maumela are recorded in evidence, but remain unverified and thus appear as untested assertion in this report. This matches Umkhonto Wesizwe submitted amendment to record them as untested allegation, with referral considered only if new evidence emerges. But unfortunately, it will be done by then, Chair. And the scope must go beyond subs. Hence, I've mentioned the issue of the National Prosecution Authority, the NPA, IDEC, the magistracy, and correctional service. Our draft does not address some of this section of IDEC and prosecution interference, but should explicitly note as limitations that certain areas were not fully investigated. For example, the evidence leaders flag allegations of criminality infiltration with correctional service and the judiciary. That has not been fully explored. We recommend that include language such as witness alleged cartel infiltration into wide range of institutions, SAPS, NPA, IDEC, courts, prison. But the committee inquires into this allegation when necessarily limited to evidence presented, in particular, one acting judge was mentioned in evidence, but no further judicial official were examined. This remains an open issue. Hence, I suggested that, perhaps in the next coming year, if Parliament, the Secretary and Parliament will allow us to regroup, and finish what we started, bring in, the judiciary, bring in the correctional service, because we've done nothing when it comes to that, Chair. If there's any percentage, I'll say maybe we've done 1% of that, because we've dealt with the NPA a bit, in terms of IDEC and Advocate Johnson and Advocate Patoi. But indeed, when it comes to the untested water, the untouchable, the judiciary, we've done nothing, Chair. And I'm going to go to the I'm not sure about Shamila Patoi because he has retired now. In terms of the law, I think the legal team will know what they must do about it. Because Advocate Patoi, 19.3, it is in our view that the draft preliminary report materially understates the significance of Advocate Shamila Patoi evidence and fails to reflect this report, which we have now, the draft, to reflect the manner in which it was experienced by members during the inquiry. In our MK party assessment, Advocate Patoi deliberately concealed the identity of the prosecutor alleged to have been compromised by organized criminal elements. And that should be mentioned in this report. Notwithstanding the repeated and direct question from the committee members, and despite the committee oversight mandate, he continued refusal to disclose the identity, even after an extensive questioning, if you remember, Chair. We tried as committee members, and most of us tried. He had the practical effect, this had a practical effect on withholding information that was central to the committee investigation. The MK party further considered Advocate Patoi to have been among the most obstructive, confrontationally and uncooperative witness to appear before the committee, with her approach frustrating rather than assisting Parliament constitutional oversight function. The attitude was beyond reproach, Chair. The draft should indeed, therefore, accurately record both the substance of her evidence and significant concern expressed by members regarding her refusal to disclose material information, rather than characterize her conduct merely as exercise of legal caution on procedural restraint. And we know what happened when he was called as well in another inquiry. In fact, he left there like O'Sullivan. The draft report should therefore state Advocate Shamil Patoi acknowledged that the information had to come to her attention concerning a prosecutor alleged to have been compromised by organized criminal elements. (19.4) on Tihas. I think Honorable Matheus has said it mouthful about Miss Mary Tihas, but I must say this as well, that I think this should be captured. That the testimony of Miss Mary Tihas and Dr. Shamila Machukha introduced allegations against the now judge, by the now judge Tihas, so inverted commas, and Machukha. The draft should accurately note that was heard Advocate Patoi testify that her decision on the directive was influenced by the unverified allegations from these sources, despite the IG and the commissioner finding them unreliable. If the draft omits this, it should state that Patoi and Minister Mkhwanazi were informed that the IG and the National Commissioner considered those allegations unreliable. And I mean, it was very, very clear. Fortunately, the National Commissioner came before us. And unfortunately, the IG, the Inspector General, could not come before us. But the National Commissioner said it clearly. And I think that has to be, it cannot be omitted from our report. Low-rate evidence, if included. If the draft touches on the testimony of the Metro Police and the police, etc., nothing. There's nothing specific then from us which we can raise a chair on that. But Minister Mkhwanazi's evidence is that Minister Mkhwanazi's testimony was problematic, and the draft must not whitewash that chair. I'll highlight 2 points on that. Mkhwanazi admitted, or on the recording of Mkhwanazi, ordering the chief of staff then, Nkabinde, to secretly record General Mkhwanazi's testimony. Advocate Arendse explicitly notes this admission. If the draft downplayed this, then this should be corrected, Chair. The minister acknowledged that he has instructed a covert recording of the witness, and that fact was highlighted by the evidence leader. And in that which I said it earlier about the consultation with the president, and that should not be downplayed as well. Because Mkhwanazi told Parliament that he consulted the president about the directive, but Arendse records that he later misrepresented to Parliament what the consultation entailed. And the report should say that at least one of the Mkhwanazi statements in Parliament was contradicted by the documentary evidence. 19.6.3, Chair. The overall evidence leaders concluded that Minister Mkhwanazi evidence raised significant concern, e.g., about the timing of the directive. The draft summary of Mkhwanazi, if any, should reflect this judgment. Perhaps quoting or paraphrasing Arendse's language is about the credibility issue. I think we have really spoken largely about the task team and the directive. I agree that maybe there should be more accountability on that. But on our draft, it should be correctly noted that Mkhwanazi issued that directive of disbanding that on the 31st December 2024 to disband the PKTT. And we are saying explicitly that the state, the way it was disbanded, it was procedural. There was procedural irregularities on that. The directive was issued later on the New Year's Eve, and we know today that was not brought to the National Commissioner, though we learned that the National Commissioner was on leave, but there was an acting commissioner. We learned, the National Commissioner said he learned it on WhatsApp. And he stated the reason, to saying that the winding down the task team came only after and were not contemporaneously, and I can tell you it's not true. The evidence before us that it's not true what the minister was misleading us. And these points are central findings from the evidence check. We know that the evidence leader summary and likely that the draft must be concluded that whether this directive was unlawful remains for the committee to decide. And I think we all agree today with all the evidence brought to us that indeed it was unlawful. Because he could not decide alone. We had the IMC, and no one was consulted, besides the president. And any making of possibility justification in our report should be balanced by noting that the evidence leaders finding that it was issued without prior consultation, and that this may, in fact, not even may, it have exceeded the minister's power. The minister's power were exceeded. The 20.2, the findings on corruption network. MKP notes that the evidence of this systematic corruption, e.g. self-procurement fraud, irregularity investigation is substantial. For instance, the evidence leaders recount that Mr. Begitele admitted about, I'll say that alleged, Chair, on this one, about the 500,000 cash payment to the former police minister during the tender irregularities, the tender of Ket Matala. But indeed, I think we now know what exactly happened. Though some of the matters, when we listen to the Nhlanhla Commission, when they cross-examine them, you know, a lot of evidence as well and information, and put it that way, it's coming from all those who came before us, and even those who never came before us, like Mkhwanazi came before us, you know, the behavior. When he went to the commission, you know, and today he's still trying to get bail. On that 20.3, section 14, I want to support the evidence leaders, Chair. Forward-looking the recommendations, in particular, we endorse the vetting reforms, the lifestyle audit, and we hope that will be done. You know, the screening of senior subs post, strengthening and continuing the PKTT. I think Honorable Martins as well said that, and establishing the Gauteng counterpart, and to reform the crime intelligence, clarifying its role, oversight of the secret self-service account. We also not the leaders call for expanding the IDEC mandate and properly operational the inspecting judge. We've got a different view in our recommendation, if we can, Chair, but that will have to be dealt with by Parliament. I think IDEC as well, it's the same as scorpions. It targets people. So for me, whether IDEC, you know, it's strengthened, for me, I think, Chair, it's debatable, but it will depend on the report. But as far as Mkhwanazi says, when we look at the IDEC, we think IDEC should be something of the past. The draft should include or preserve these recommendations, which are largely anchored previously by our submission on the anti-corruption oversight. If there's any specific recommendation from the draft which contradicts the evidence, for example, a weak or non-binding probe of the crime intelligence cases, it should be strengthened. The crime intelligence should be strengthened. Finally, Chair, we really support and include the recommendation from 47 that all incoming national commissioners, indeed, perhaps must be, Parliament has to be involved, you know, in a way. But hence I'm saying other matters needs to go to Parliament, because for us to suggest that, it means the Constitution has to be amended. Now, when you go to section 15 on that public comments again on those dissenting views, the report should really, the report format allows the minority on additional views. Now, as MKP, we append further comments. For example, it must emphasize the need for the committee to consider the classified IG report from crime intelligence, mentioned in evidence but not delivered. I think Honorable Martins as well touched the issue of the letter which was sent to me. And I think General Mkhwanazi as well received that letter. And I even said in the committee that I received a call, a known call on 012. We're told that was a public phone. The prim letter and any written affidavits filled at the end, all noted by Arenze, must be captured in this report, because that was a new evidence. The items and their procedural status, in particular, the unanswered letter from Germany Prim handed in the last hearing, should be listed as an exhibit received but not fully verified. At least, Chair, it must be captured in the report. Finally, Chair, Mkhwanazi party submits that the report be paginated and indexed as per parliamentary practice. Sections should have clear headings matching their content, and all quotes or factual statements drawn from this evidence should be footnoted as done here, and the text should be fully justified and spaced on 1.5 lines through the final document. Where direct quotes from the witness or the evidence leaders are used, they should appear in verbatim with citations. Where paraphrasing is used, it should still reference to the source lines as done above. Mkhwanazi party offers this submission in the spirit throughout oversight. We trust that incorporating these corrections like I've done that. We've done that as Mkhonto Wesizwe, but we on this report we still see that they've been omitted. This should be incorporated. This correction and clarification will ensure that our report faithfully reflects the parliamentary record. In summary, we emphasize that the report must note the president's written answers and that no oral testimony was given by the president. He was given a special treatment. I know that one, there'll be some issues on that, but he is the only one who gave oral testimony, Chair. It should be also recorded that General can never testify. And Chair, I think for now I'm done. Thank you, Chair.
So you say it provokingly. You say, I know that is going to provoke other members.
Yeah, hence I don't want to go much on that. But the issue is that he is the only person who never who made some written response. There was no oral. Yeah,
we dealt with that matter in the last meeting, and it was this committee as well that decided not to invite General Khan. The committee
yeah,
has
no problem, Chair.
It's written in its terms of reference that it will decide on the witnesses that appear before it. The Honorable Sokanyile. Honorable Sokanyile. Honorable Ntuli, the Chief Whip. Okay, honorable members, it means that Honorable Skosana was the last speaker for this item. This is what we are going to do now. Maybe before I allow the content team to express themselves, let me say the following. We have given members time to talk to the draft report. This was the second draft preliminary report. And from the inputs that members have made, it's very evident that we will still need other draft before we send it out. Members will guide me whether they still need a meeting or the draft can be circulated. And if they are happy with its content, we can send it out and then we will come. The strongest feeling that I get is that the adoption of the committee report has to be done in a physical meeting. That is what I read from the sentiment I read from the meeting. So, number one, I'm going to request members, if there are members who would have added to the submissions that they previously made, they will have to forward that to the content team. And for sure, the content team also has contacts of members. If there is a member who would have said something here, they have not properly captured it, or it does not appear to be very clear in the recordings, they can always call the member and clarify with them how certain aspects of the report may be improved. The content team has written a report, and the appeal I want to make is that Members must not engage with the report as if this is not their report. The content team has laid a basis for engagements, and they have now taken the report back, or they have now brought the report back to members to say, we are not members of the ad hoc committee. We are your support staff. And this is what we have written. We now want you, within the framework that you have adopted, make this report to be the way that you will appreciate it, the way that it will meet your expectations, and the way that it will fulfill the mandate for which you have been appointed. I would like to commend the members for the manner in which they engage with the report. And let me assure you, the content team is very professional. Like I previously said, they have heard everything that you have said here. Your emphasis that we are a committee of parliament, which is an institution that exercises oversight as one of its constitutional mandates. And members say that we need to come out vigorously in our oversight work, but most importantly, the language that is used for oversight must not be interpreted to be negotiated. The language must be uncompromising. The language must be forthright, and to some degrees, it may have to be unambiguous, so that whatever statement we make out there, ordinary citizens of this country reading our report must understand that this report comes from an oversight arm of the state. And members are saying that we have gone past the stage of assessment. Evidence has been presented before us. And there were numerous examples that were made, particularly around IPID, to say we have had the evidence by McBride, we have had the evidence by Mr. Paul O'Sullivan, Miss Sarah Jane Trent. They went to the house of General Pathani. They were not IPID officials, but they went there. McBride knew about it. And there has been an improper relationship or an irregularity had occurred there. If you go back to the recording of proceedings, you would know members have been asking questions whether an ordinary citizen can find himself or herself involved in routine IPID operations. So findings like those have to be made, and members have also suggested, in respect of every finding, the final draft which must come has to link recommendations with findings. In respect of every finding, there must be a recommendation. Where there are the recommendations for legislative reform are made, like in the case of intelligence services, let's have those in civilian secretariat. Let's have those recommendations coming out very strongly. And where we recommend that further investigation has to be made by the respective law enforcement bodies, those recommendations should come out. Whatever referrals are made, they should come out very clear that this matter is being referred for further investigation. Those by law enforcement agencies or by respective bodies like those that would be referred to the committees of parliament, like the ethics committee. members are saying, let's have those coming out vigorously in the report. We need to be, they must come out glaringly for everybody to see that these are the findings that the committee has made, and these are the recommendations that the committee is making on those specific findings. And I think today, like in the last meetings, the last fiscal meeting, members have spoken in a chapter and a verse. And I'm going to request the content team to make their remarks. And after making their remarks, indicate when can they be ready to release the third draft, which members will have to see before we send it out to the affected parties for their comments. Ms. Van Zyl-Gous, any comments?
Thank you very much, Chair and honourable members, for the comments and input. Chair, we can commit to having the draft out by no later than Thursday or even Wednesday. No, yeah, Thursday or Friday, Chair, honourable members. Thank you.
Yeah. Let's say Friday.
Perfect. Thank you, Chair.
Yeah, let's say Friday, because I know that I'm always reminded of the words of Honorable Breitenbach that these people are human beings. We must not do things hastily. They put pressure. I think even if we miss the deadline, it may be by not more than 5 days. I don't think it will harm a fly. So let's give until Friday. And even if Friday is not possible, indicate to us and say, we have aimed at finishing on Friday. We request that we submit on Monday or Tuesday, whatever is possible. Agreed?
Thank you very much, Jay. We will do that.
Ms. Silkstone?
Chair, I don't think I have anything to add too much. I just wanted to say that I think what might actually assist is if we distribute a document that we prepared where we put together all the proposals that we got from parties, and just to see many of or some of the things that are raised have been captured in the report, but perhaps we need to revisit them and just see whether that it's sufficiently clear. But obviously anything that's new or that we've missed, we will do our best to rectify.
Yeah. Well, I think in a significant number of cases, it's just to strengthen the language, which I don't think there might have been a few omissions, which I think you would have been brought to the attention of the meeting today. And yeah, a significant number is about strengthening the language and foreground the oversight role of Parliament. So that Parliament must not be seen like it's a lame duck. Let's reignite public confidence in Parliament that Parliament can go and investigate, do the assessment of evidence, and then make recommendations with far-reaching implications. Where further investigations have to be made, those investigations have to be made, including the regularity of reporting before Parliament. Some matters may need quarterly reports in the portfolio committees. in some matters, we can determine the timeframes on how often they should be reported to Parliament, so that Parliament is able to make follow-ups where there are delays or where there are no reports forthcoming. Parliament should take note of that and be able to make necessary follow-ups. Yeah. Is that okay?
Yeah.
Okay.
Okay, I don't know whether Nicolette wants to just to step in here, but there are one or two technical reasons why we crafted findings and recommendations in a particular way. And I don't know, but they're technical and well, they're content related. And I wanted to know whether Nicolette wanted to just discuss them very briefly, specifically around the way we framed the civilian secretariat recommendations or proposals made by the ANC, and then the other one was the employment conditions and the kind of proposal that the PSC and the State Law Advisor looks at that. Nicolette, are you comfortable to? Our recommendations kind of worked around that. So we noted the concern, but we framed it in a particular way. But I think Nicolette might be able to explain better why we felt as a content team it was necessary. But obviously it's subject to how the committee feels.
Yeah. No, she can take us through, and I think the committee can have a take on that.
Thank you, Chair. Thank you, Chris. Chair, I think I'm not going to go through the entire list of issues. It will be made available to members, and for if I can use an example of the ANC recommendation or finding that the Civilian Secretariat for Police should be modelled on the Civilian Secretariat for Defence, where the Civilian Secretariat for Police will become the accounting authority of the police, as is done with the Civilian Secretariat for Defence. Now, Chair, with that, but we will write a brief on that. The accountability model of the Civilian Secretariat for Defence has a lot of challenges in terms of governance, in divorcing the accounting authority from the operational authority. Chair, but that is just one example, but we will, and Chair, the point to make is not a criticism. How we structure it is that the Civilian Secretariat for Police, the governance structure should be reviewed. And similar with IPID, another example is that IPID and the Civilian Secretariat should be merged into one authority. And also on that, I will give a brief written explanation as to why they were created and the constitutional, I want to say the constitutional ideals in terms of why a Civilian Secretariat for Police should be established, just in terms of the significant powers that the police has over citizens, depriving them of significant basic human rights, even, the right to use lethal force, such in that a Civilian Secretariat and to monitor the policy development of the police, and then the IPID to monitor the use of policing powers. They are quite distinct and separate constitutional obligations, and that the SAPS and SANDF is quite different structures within our constitutional democracy. Gee, but there's just two examples. But like I say, we will provide a short written document on just content notes as to why certain issues were not included. And to give another example, Jay and honorable members, iPad is free to recruit from anywhere. They can recruit independently. They often do not recruit from SAPS or anywhere. There is specific safeguards in the iPad Act, in that the service benefits must be equal to SAPS detectives as to prevent iPad investigators to go over to the once iPad has trained the investigators, for them not to jump over to the SAPS for better employment benefits. Gee, so yeah, there's a couple of issues that we can address and should have actually already provided to the committee, Jay, but the document is available on which we made notes on the submissions. But Jay, yes, that is just a couple of examples on what we were thinking as content team. But Jay, let me leave it at that, and I submit. Thank you, Jay.
Thank you so much. Can I check if there is anybody who wants to comment? The ANC? The MKP? The DA?
All good. Thank you, Chair.
Okay, the EFF?
Thank you, Chair. We're fine.
Thank you. The IFP?